nothing, because it would mean that we have to accept that our population, 500 million people, whenever they use the internet in one way or the other, they are subject to continuous, indiscriminate mass surveillance. And that is something not only the people in Europe can't accept, that is also something the European Court of Justice would never accept. As we have seen, in the Data Retention Directive, the European Court of Justice has annulled a European law which allowed indiscriminate collection of metadata. Hello, America, read this judgment. So David, to spice up and to give you a nice entry, to spice up your talk, we hope very much that the P Club will give an interpretation to its mandate which includes this concern of Europeans, and that the work of the P Club contributes to getting rid of this enormous liability on transatlantic relations. We hope very much, and we believe actually, and we see it, that many Americans agree. They also don't want to be spied on in an indiscriminate fashion, and American companies want to keep customers worldwide. So to close, my view is that there is a large alliance of Silicon Valley economic interest and power, civil society, European politics, American politics, which can make it possible that we get this right. But America, because of its great capacities, must take the lead on this, and the work of the P Club can make an important contribution to it. So thank you very much again for being here and discussing with us.
Thank you, Paul. David Medine is, as we know, chairman of the US Privacy and Civil Liberties Oversight Board. He started as chairman on 27th of May 2013, which I think is about a week before the first Snowden story was published. He's a former attorney fellow at the Securities and Exchange Commission, special counsel at the Consumer Financial Protection Bureau. He has advised the White House National Economic Council. When at the Federal Trade Commission, he was part of the team that negotiated the Safe Harbor Agreement. And on the 7th of August this year, the board announced its short-term agenda. And it was interesting to note that one of the items, correct us if I'm wrong, please, David, now, time may have moved on. One of the items was about the privacy protections to be provided to non-US persons under Presidential Policy Directive 28 relating to signals intelligence. Please welcome David Medine.
Thank you, Paul, for your introduction, and thank you for the other Paul for your comments. And I'm delighted to be here. I'm also delighted to be sitting between Jan and Paul. I think we've had a very civilized discussion of some very, very important issues of how to balance national security with privacy and civil liberties, which is the mission of our organization. I also agree that the debate on collection versus use is a very important one, and I think it's something important for us to address going forward. I have to start by saying that my views today don't necessarily represent the views of the Privacy and Civil Liberties Oversight Board or its members. These are my own views. I also wanted to thank the Data Protection and Privacy Commissioners for having me back, and for our hosts in Mauritius, particularly Commissioner Madhub, for having us here today. Since my last attendance at the meeting, our board has issued two reports, one on the 215 program and one on the 702 program. When I heard the topic of this discussion today, surveillance versus dataveillance, I really don't understand the question, but I decided to at least use our two reports as perhaps some guidance as to how to, what's referenced here in competing values. I want to start with the 215 report. The 215 program involves collection of phone numbers, and which numbers were called by which phone numbers. It did not include the contents of the call or the location of the caller, simply the numbers dialed, the number receiving the call, the time of day, the length of call. But this information was collected across the United States on citizens, whether they were under any suspicion or not. My records are probably sitting in the NSA, as is Julie Brill's and Edith Ramirez as well, and the others who might have called them or us in the United States. So that is in some ways what I would refer to as a bulk collection program, where there's no suspicion regarding the information collected by the program. So our board took a very close look at the program. We had some very serious legal concerns with its functioning, raised some constitutional issues, but on the policy grounds of privacy and civil liberties, found particular concerns, because when you collect what numbers people call, what you're revealing is not just phone numbers that are unassociated with anybody or anything. Citizens now know certainly that information is being collected. And what that means is if a source, say inside the government, wants to call a reporter to blow a whistle on some problem, that source now knows the government is collecting that calling information. If religious and political dissidents want to gather together and lawfully petition the government or assemble, they now know the government is collecting that information. And I think it's highly likely that will chill people's exercise of their privacy rights, of their speech, religious, and association rights. So we started off with some major concerns about collection of information without any justification at all. It was not relevant to any particular investigation. So then we said, okay, let's look at the other side of the equation, which is this program effective? Is it protecting national security? And we analyzed all of the cases in which the government asserted that the program had been effective. And what we found is in no case had it thwarted a terrorist plot, and had minimal value based on a number of other metrics, and even that minimal value could have been dealt with by other government programs. So on the one hand, we had some very serious privacy invasions. On the other hand, we had very little value. And so our board called for the termination of that program. President Obama has essentially agreed to that, and there's legislation now pending in Congress that would do that. Instead, we've said is that that where there is a particular reason to have suspicion about a particular phone call and phone numbers, that you go to the phone providers and get that specific calling information, rather than having the government be a repository for a vast amount of everyday people's communications. So that's one program that we looked at which involved bulk collection. By contrast, we also looked at the 702 program. The 702 program collects the content of email communications, collects the content of telephone communications, but it has some important limitations. One is it has to be specifically targeted. It's not a bulk collection program. There's been a lot of misinformation about that. It is a large program, no doubt, but it is not a bulk collection program where information is collected indiscriminately. In order to target an email address or a telephone number, there has to be first foreign intelligence value to that communication. That is, they have to already know that there's a reason likely to expect foreign intelligence deriving from that information. You may not like the second part of this, which is that you have to be a non-U.S. person. We'll talk about that in a moment, to be a target under 702. And you also have to be outside the United States, whether you're American or non-American. And so this is a program that is specifically targeted. So the question is obviously, nonetheless, collecting people's content of their phone calls or their content of their email obviously raises very significant privacy concerns. People might include family pictures, personal communications that are quite sensitive, and so there's clearly a privacy interest on the one side. But then we also look at the benefits and the effectiveness of the program. And in contrast to the 215 program, under the 702 program, which is sometimes called PRISM, there are parts of it are called PRISM, parts of it are called Upstream. What we found is the program had actually been very effective. It had thwarted a number of terrorist plots, and it had contributed significantly to national security and the intelligence by which our officials operated. And so again, given that balance, we concluded that the narrow focus of the program by specifically targeting was justified. We did recommend some particular changes in the program, and I was somewhat heartened to hear that I was actually a partial dissenter, because I would have also required that when the government searches that database that is now collected for particularly Americans' communications, that there be court approval and that the government not be free to search the database. I was in the minority on that position. So again, what I would do is contrast these two programs between a bulk collection program and a targeted program. Now that's not to say that every bulk collection program is bad. That's not to say that every targeted program is good. But I think it's a starting point in the analysis to see, first of all, what is the justification for the collection of the information? What is the effectiveness? What's the privacy and civil liberties impact in collecting the information? So particularly I think regarding bulk collection, which again I think has very significant impact on privacy and civil liberties interests. So turning forward in the board's agenda, and as was mentioned, we have two significant items on our agenda. One is when President Obama spoke last January, he announced his Presidential Policy Directive 28, which calls for more comparable treatment by non-U.S. and U.S. persons with regard to our intelligence program. In part because that process is going forward, we chose not in our 702 report to delve as heavily into that, because that would have been a narrow focus, and PPD 28, the Presidential Policy Directive, is a broad focus on the national security programs that we operate. But at the very end of PPD 28, the President called upon the Privacy and Civil Liberties Board and invited us to conduct an oversight of the PPD's implementation, which we have since said that we would do. And so there will be at some point, probably early in the next year, a report that we'll issue. It all depends on the timing of the PPD implementation, but presumably it could be approximately a year from the President's speech, and then obviously it'll take some time for us to assess it. But for us to issue a report on how that program has been implemented. I'd also mention that in terms of our agenda, we have, and this was mentioned a moment ago as well, announced that we would look into Executive Order 12333, which is a broad mandate for the intelligence community in the United States to operate beyond those programs that are operated under 215 and 702. That's going to be because of its breadth and its implications for our 16 intelligence agencies, it'll be a long-running project, so I don't expect a report in the next few months, but it's something that we're going to take a close look at, and I think it does have some significant issues that it will raise, and then we will address again to try to strike the balance as we have before between privacy and civil liberties on the one hand and national security. The last point I wanted to mention is there was a discussion of information retention, and again I was in the minority on this with one of my colleagues, but we are concerned that the government has procedures to delete information that's not relevant to foreign intelligence after it's been collected. And that sounds good in practice, because once it's gone, it can't be searched, particularly because it won't have any bearing on national security and foreign intelligence. But what we found is the government actually doesn't do very much of that in practice. A lot of the information is collected and never really sorted through and deleted. Even sometimes after it's been reviewed by an analyst, it isn't always sorted through and deleted if it doesn't bear on foreign intelligence. Judge Walt, one of my colleagues, and I would like to have seen some judicial oversight of that so-called minimization process, where irrelevant information is deleted, to make sure, again, personal pictures and sensitive communications don't sit in the files of the government. And we do hope that there'll be some more rigor to that process, so that even if information is retained longer, it's only information that has a foreign intelligence purpose, and not information that just happens to have been collected in a government program. So with that, thank you, and I'd be happy to answer questions.
Thank you, David. Paul, can I ask you to set up the other end? Because I've noticed throughout the day that if someone's there, many people in the room can't see them. And I'll stand here. We've got a few minutes for questions. There are some microphones in the room, I think. Could you wave your hand? I've got some lights in my eyes. Are there people still with the microphones? If not, you should shout. Anybody got any questions? And if you've got something to say, can you keep it short? Sure, well, I've had a request. The request is, why don't we let the panelists talk to each other, because they're so interesting. Can I check that by acclamation? Okay, they're not only interesting, they're popular, David, thank you. Can I start it off just by asking David In looking at your 215 report and your 702 report, it was quite striking that there are dissenters on the board. Sometimes it's you, sometimes it's not. Sometimes it's dissenters who are, as it were, more conservative. Is that a fair reflection of the kind of environment you find yourself working in?